Mohini Jain versus State of Karnataka 1989. Whether the right to education is guaranteed to the Indian citizens under the Constitution of India? In Mohini Jain case, the Supreme Court held that the right to education is concomitant to the fundamental rights enshrined under Part-3 of the Constitution. The right to education flows directly from right to life. The Parliament in 2002 passed the Constitution 86th Amendment Act of 2002. It added Article 21A to the Constitution and expressly recognized right to education as a fundamental right in the Constitution. Background: The state government of Karnataka issued a notification dated 5th June 1989 under Section 5(1) of the Karnataka Educational Institutions Prohibition of Capitation Fee Act 1984, fixing the tuition fee, other fees, and deposits to be charged from the students by the private medical colleges in the state. As per this order, 3 different fee slabs were fixed. First, for the candidates admitted against government seats, the tuition fee per year was Rs 2,000. Second, for the Karnataka students other than those admitted against government seats, the maximum tuition fee was Rs 25,000. And third, the students belonging to the category of Indian students from outside Karnataka were to pay the tuition fee not exceeding 60,000 rupees per annum. Mohini Jain was a resident of Uttar Pradesh and she came under the category of Indian students from outside Karnataka. Mohini Jain was informed by Sri Siddharth Medical College, a private medical college in Karnataka, that she could be admitted to the MBBS course in the session commencing February or March 1991, provided she would deposit Rs 60,000 as the tuition fee for the first year and furnish a bank guarantee in respect of the fees for the remaining years of the MBBS course. When she could not pay the exorbitant annual tuition fee, she was denied admission. Mohini Jain, under Article 32 of the Constitution, challenged the notification dated 5th June 1989 issued by the Government of Karnataka, which permitted private medical colleges to charge exorbitant tuition fees from the students other than those admitted to the government seats. Arguments: Sri Siddharth Medical College, which denied admission to Ms. Jain, contended that the students from whom higher tuition fee was charged belonged to a different class. It said that those who were admitted to the government seats were meritorious and the remaining non-meritorious. The classification of candidates into those who possessed merit and those who did not was not a valid classification, and the college management was within its right to charge more fee from those who did not possess merit. The object was to collect money to meet the expenses incurred by the college in providing medical education to the students. The Karnataka Private Medical Colleges Association argued that private medical colleges in the state of Karnataka did not receive any financial aid from either the central or the state governments. They submitted that the private medical colleges would incur about 5 lakh rupees per student as expenditure for a 5-year MBBS course, and 40% of the seats in the colleges were set apart as government seats to be filled by the government. The students selected and admitted against government seats would pay only 2,000 rupees per annum, and the rest of the burden was on those who were admitted against the management quota. The tuition fee was not excessive, and as such, there was no question of making any profit by the private medical colleges in the state of Karnataka. Sri Siddharth Medical College and the Karnataka Private Medical Colleges Association submitted that in order to run the medical colleges, the managements were justified in charging the capitation fee. They also submitted that there was no provision under the Constitution or under any other law except the law passed by the state of Karnataka, which prohibited the charging of capitation fee.